For many years, my colleague, the junior senator from Minnesota, was a talented comedic writer and comedic actor.
Thank you.
And
I agree.
Indeed, he had the honor of working for many years on Saturday Night Live, a show I grew up watching.
Thank you.
A show that has had, over the years, fantastic political satire.
Thank you.
Indeed, I can recall the 2008 election cycle, the caricature that Saturday Night Live did of the Republican vice presidential nominee, Sarah Palin, was wickedly funny, but also tremendously effective in impacting people's views of that vice presidential candidate.
Yeah.
My friend has just voted for a constitutional amendment that would give Congress the power to prohibit corporations like NBC from spending money to influence elections. Does the senator from Minnesota believe it should be constitutional for Congress to say NBC and Saturday Night Live cannot run satire that criticizes politicians and influences elections?
I don't think that would be reasonable.
But I would note the reasonableness is not in that section. It's in Section 1. Section 2 says prohibiting, with no reasonableness.
Look, we
it says
did
prohibiting.
Before, that was before Citizens United, and you'll notice that the sketch was on, that Tina Fey was able to do Sarah Palin. Well, you'll notice that in 2000, Jim Downey wrote a devastating Al Gore in those debates that I think may have affected that election, since it was since Al Gore won the plurality of the vote in that election. I think that this parade of horribles that you're talking about is just not realistic. I think what the court said in Austin is something that we all know, that money can not only present the appearance of corruption, but can corrupt. And when people can literally spend hundreds of millions of dollars, I think that's of their own money that does create the appearance of corruption. I think Justice Kennedy was just wrong in his decision. And that's my opinion. There are Supreme Court decisions that you disagree with and that you support amendments to overturn. So, you know, I just think that this is reasonable. This is what existed. This was the law as it existed before a 5-4 decision. And I agree with Senator Hirono that I think people would feel a lot better if it wasn't a 5-4 decision from a court that's made a lot of 5-4 decisions that seem to go in a certain direction.
If I might ask a follow-up question. The senator from Minnesota just said that this amendment would simply restore the law as it existed prior to Citizens United. That statement is objectively false. It goes much, much further than reversing Citizens United. For example, it was not the law prior to Citizens United that Congress could pass a law banning corporations like NBC, like Saturday Night Live, a show on NBC. It was not the case, consistent with the First Amendment, that Congress could pass a law prohibiting NBC from spending money to influence elections. This amendment goes much, much further than Citizens United. But the question I would ask is, the senator from Minnesota suggested that what I have described as a parade of horribles. I would suggest it follows directly from the legislative and the constitutional language you have just voted on. And the question I would ask in particular is the senator from Minnesota criticized the Citizens United case as describing it, I forget the terms, but in very bad terms, whatever the adjectives were that were applied.
I'm not going to hold you for the exact quote.
I appreciate that. I would note, the question I want to ask is whether the senator from Minnesota believes that Congress should be able to ban movies. And if the answer is no, Citizens United was about Congress fining a movie maker for publishing a movie critical of Hillary Clinton. So if you think Citizens United is wrong, I think it is very difficult to reconcile that position with the position that Congress cannot ban movies.
I think the court decided a different question than it was asked in Citizens United. I also believe that Congress did have the rights to put limits on corporate spending before Citizens United in certain ways.
Would the senator from Minnesota yield?
I would.
Perhaps I could help to clarify.
Yield.
Because influencing elections is generally deemed a term of art. And so there is nothing in the Durbin Amendment that would prohibit corporations and other entities from engaging in issue advocacy to their heart's content. And that is really what was the case before Citizens United.
I might add, Senator Arano, Senate Joint Resolution 19 authorizes Congress and the states to implement reasonable, content-neutral regulations on campaign contributions and spending. This framework is consistent with time, place, and manner restrictions that the Supreme Court has long held satisfy First Amendment scrutiny. As the Supreme Court noted in Virginia versus Black, the protections afforded by the First Amendment are not absolute, and we have long recognized that government may regulate certain categories of expression consistent with the Constitution. You cannot falsely yell fire in a crowded room because freedom of speech doesn't give anyone the right to cause a stampede and potentially harm innocent people. You have to get a permit to protest in certain public places because freedom of speech doesn't give anyone the right to jeopardize public health or safety. We certainly know the laws as they relate to pornography, particularly the exploitation of children. By the same token, you shouldn't be able to use millions of dollars in secret special interest money to undermine the constitutional rights of average Americans to participate in the political process. I would just close by saying that we will, without objection, enter into the record any communications received for or against Senate Joint Resolution 19. The communications favoring Senate Joint Resolution 19 include one that has been signed by Greenpeace, the NAACP, and the National Education Association, groups that the ranking members suggest are going to be somehow censored and prohibited from their right of free speech. They are, in fact, supporting Senate Joint Resolution.
Would the chairman yield for a question?
I'd be happy to.
I would ask the same question that I asked the senator from Minnesota that he declined to answer, which is, number one, under the text of this amendment, could Congress ban political movies? Could Congress ban books? And would it be constitutionally permissible for Congress to prohibit the NAACP from speaking about politics?
I would say to the senator what I've said earlier. What we are talking about is reasonable, content-neutral regulation. What the senator has suggested in his parade of horribles, going back to your logic course, reduction ad absurdum, is not going to carry the day in this debate, nor with the American people. And
are you willing to answer any of those questions, yes or no?
I've just answered those questions by saying that
I'll answer them all no. Do you,
if you're going to reduce this to the absurd, we'll be here for another hour and a half.
Should we be able to ban movies, yes or no? What's absurd about asking that question?
No, and there is nothing about banning movies in this amendment. Subcommittee stands adjourned.